Good morning, ladies and gentlemen, and welcome to the Wisconsin Act 12 webinar put on by Attolles and the Attolles team led by Andy Phillips. The shared revenue legislation, currently referred to as Wisconsin Act 12, was a long and difficult journey led by Representative Tony Kurtz, Senator Mary Felskowski, Senate Majority Leader Devin LeMahieu, Speaker Robin Voss, and our very own Kyle Christensen. And there were ups and downs and in-betweens, starts and fits and everything that you can imagine. But in the end, all parties came together for really what is one of the most, I would say, innovative and creative mechanisms to convey state dollars to local units of government to put our state in a position for success. Now, while we focus on the dollar amounts that we received and then the automatic increases we will get compared relative to the state sales tax increases, there is much more to Act 12 than just those items. And here to explain it today is the Attolles team led by Andy Phillips. So without further ado, Andy, take it away.
Thank you, Mark. Good morning, everybody. Thanks for joining us today. I've often heard the legislative process be described as making sausage. And so you don't ever want to see the process that occurs. You just want to look at the end product and try to take a look at it. I say this because Act 12, as Mark mentioned, has many, many components beyond just the change in the whole shared revenue system. And it was through a back and forth negotiation discussion about importance from a legislative standpoint, importance from a county government standpoint, importance from a municipal standpoint that resulted in what we have in the final law in Act 12. Today's going to be a discussion. If you're coming here looking for final answers on application of every element of Act 12, we don't have it for you because a lot of these things have to work out. And what I mean by that is that, as you probably know, there are certain provisions in Act 12 that require administrative rulemaking. We don't have the rules yet. And so we don't have an understanding of, from an administration standpoint, how the Department of Revenue or Department of Administration is going to look at some of these provisions in Act 12. So we too have certain questions about how Act 12 is going to roll out. And so today I want to focus on some of the finer points in Act 12. As Mark mentioned, the non-fiscal components in Act 12. We're going to talk a little bit about the shared revenue process and how that looks. Don't ask me or my partner, Matt Thome, who's on here with me, to do math, because that's why we became lawyers, so we wouldn't have to do math. So we're not going to get detailed math in this presentation, but we are going to touch on some of the elements that relate to fiscal policy in Act 12. Because I said this is a discussion, that means you have an opportunity to ask questions and make comment. And so on your screen, you should have a chat button and a Q&A button. If you want to ask questions or make a comment, use either of those buttons, and we'll do our best to get to those. Good, and we already had in the chat, is this presentation going to be recorded? Yes, it's going to be available at the Counties Association website shortly after we are done here today. So without further ado, let's talk about Act 12. And we're going to have, this is just an overview of what we're going to talk about today. We're going to first talk about the changes to the shared revenue process. We're going to talk about maintenance of effort requirements. We're going to talk about levy limit adjustment provisions that are contained within Act 12. We're going to talk about quarries, and we're going to talk about other issues. And you're looking at this right now saying, okay, 1, 2, and 3 makes sense based on everything I've heard and read about Act 12. What are you talking about quarries for? Well, believe it or not, there is a provision in Act 12 that speaks to the ability of local governments, primarily towns, to regulate quarries, but it does impact counties in that it takes away certain authority that counties currently enjoy as it relates to the regulation of non-metallic mining. And then we're going to talk about other issues. Like I said, in that entire process of coming up with Act 12, it was a give and take discussion and negotiation about certain priorities making their way into Act 12 in exchange for an overall support of that legislation. So, Matt, I know that I've talked a lot thus far and not given you the opportunity to speak. You actually put a tie on for today's presentation, which is incredibly impressive. It makes me feel a bit ashamed. Anything you want to add before we start?
No, I don't think so. Looking forward to a good discussion.
All right, so let's start with the changes to the shared revenue. Essentially what Act 12 does, and I say this understanding that Act 12 contains provisions as it relates to shared revenue that were modified by Act 19, the biennial budget bill. And so you always have to look at the provisions of Act 12 as they were modified by Act 19. And so when we look at Act 12, what Matt and I both did in preparation for today as we sat down with not only Act 12, but also Act 19 by our side as well to find out what did Act 19 change in Act 12. So as a general proposition, we have a trust fund that is created, and that trust fund is where the money that will be dedicated to shared revenue is deposited and where the money comes out of for purposes of the shared revenue payments. So for 2024, counties and municipalities are going to receive the same amount of general aid that was received in 2023. Starting in 2025, that's where we're going to see a wholesale change in the way that shared revenue is calculated. We're going to have a continuation of the funding amounts that occurred in 23 and 24, but the calculation used to get to that funding amount is going to be different, and there are add-ons associated with that. As Mark indicated, there is a share of the state sales tax that is going to go towards shared revenue. It does this, or that happens by virtue of this trust fund, so to speak, that is created within the state budget. And again, that is all delineated in Act 19 in terms of the actual dollars that are going into that trust fund. The reason it's a supplement, the reason it's an add-on is explained in Act 12 through the creation of various accounts within that trust fund, where we see things like supplemental county and municipal aid identified, and we see an innovation grant and innovation planning grant program that's created. And so those accounts fall under that trust fund, so to speak, the new shared revenue trust fund. And so when we think about the separate accounts that are within that trust fund, there are strings attached to them. Okay, the supplemental aid is not just money that counties can spend on whatever they want to spend that money on. That supplemental aid is targeted to the various categories that are identified on this slide. In other words, the money that comes to a county in the form of supplemental aid has to be spent on law enforcement, fire protection, EMS, emergency response communication, public works, courts, or transportation. And I know that these lists and this list and all of these items on the list in some form or fashion comprise a significant portion of a county budget. So that's good. But there is one omission here as it relates to counties that comprises a significant portion of every county budget, but it's not on this list. That's human services. And so the question that I've received, and I know the association has received thus far, is, well, can we spend supplemental aid on human services? And the answer is no, you can't. But there is nothing in either Act 12 or Act 19 that would prohibit a county from swapping money out among two different departments. What I mean by that is, let's say, for example, that you spend $10 million on your sheriff's department. That $10 million of levy that currently goes to the sheriff's department, you know that you can use supplemental aid to fund law enforcement, fund your sheriff's department. So when supplemental aid kicks in, you can take that 10 million that would ordinarily be paid to the sheriff's department out of levy, reduce the levy contribution to 8 million. That frees up 2 million to transfer over to human services. Again, there is nothing that in the law that says you cannot do that. Your sheriff's department is still going to receive $10 million. It's just 2 million of that is going to be the supplemental aid, and 8 million is going to be levy. And you're taking the 2 million in levy that would have otherwise gone to the sheriff's department and moving it over to human services. That is an example. Okay, so I just want everybody to understand that even though the supplemental aid has a delineated category of expenditures for which supplemental aid may be utilized, that it does not prohibit the shift of levy funds from one of these delineated departments over to another department. There is an absolute statutory bar on the use of supplemental aid for administrative services. We get that. And when we talk about the how much does a county receive in supplemental aid, there is a formula contained within Act 12 that delineates exactly what that supplemental aid is going to be. Again, it's a long formula, so take a look at that. If you have questions about that, please reach out to either Dale or Kevin at the Counties Association. They've been through this with a fine-tooth comb and done a fantastic job of explaining exactly how these various aid payments are calculated and distributed. Forward analytics, that's the research arm of the Counties Association, some incredibly brilliant minds, Kevin Daspoy and Dale Knapp, that work with forward analytics at WCA. They put together what I thought was a very, very nice, simple chart explaining to people like me who are not Will Hunting, figuring out math, how this entire process works. And you can see year by year how shared revenue works. So we've got 2023, we know what the allocation is going to be as it relates to those aid payments. 61.5 million July 2023, 61.5 million November 2023. For 2024, we see an increase in the shared revenue. We go from 61.5 up to 34 million in each payment. And then in 2024, we see the transition that Mark spoke about at the very beginning of this discussion. We see the transition away from a set amount that the state appropriates through the budget process to a calculation based upon sales tax revenues generated with the state sales tax. In other words, a county's payment in 2025 it's going to correspond to the growth in sales tax revenues. And I've heard this explained by Mark numerous times, a desire that counties be funded at a level commensurate with the way that our society is spending their money and generating tax dollars. And that's awesome. And so we see here in 2025, finally, counties get to benefit from expansion of the economy. If there's more commerce going on, more business being conducted, more people buying goods and services that are subject to sales tax, then counties realize increased revenue as a result of that increased economic activity. So in addition to what we just explained as it relates to the state aid payments and the supplemental aid payments, we also have additional changes to shared revenue. As I mentioned, Act 12 contains a series of accounts that identify a change in the way that shared revenue is viewed under current law. We have this innovation grant program where additional funds are available to counties and municipalities who agree to transfer certain services among themselves and municipalities to nonprofit organizations or to private entities. There are various requirements associated with or qualifications, if you will, associated with the receipt of money out of that innovation grant program fund or innovation planning grant program fund. There are requirements that relate to the agreements that a county needs to enter into to qualify for payment out of that fund, okay? The transfer also has to have projected savings of at least 10% associated with the cost. It prioritizes grants involving public safety, fire protection, and EMS. It imposes caps, and then it, like I said before, with the innovation planning grants for municipalities under 5,000 in population, then those municipalities can apply for these innovation planning grants. Those grants can be utilized to pay the cost of personnel and consultants associated with planning for some sort of consolidation or transfer of services. Okay, so we have one question here, address it. So same shared revenue in 23, shared revenue plus supplement in 24, and new formula with sales tax in 25. That's a very, very easy way of explaining how shared revenue is going to work, is that there is a transition from 23 to 25. 25 is full implementation of the sales tax share, if you will. 24 is a bridge the gap. 23 is status quo. Matt, anything you wanted to add in terms of the various accounts and funds and the way that the math works on shared revenue?
No, I mean, obviously, these aren't the only accounts that are provided for under Act 12. I would encourage folks to go and actually review the bill and see if there's any other particular accounts that might be potentially applicable to your county. And, there's also some minor statutory exceptions and things like that. So, as with anything, this is just a general overview, and the devil is in the details sometimes.
And so there's a question, what if sales tax revenue goes down? Are counties going to be hurt by that in terms of a reduction in funding that they will see in the year where that sales tax goes down as compared to a previous year or years? The short answer to that is yes. And so if the economy contracts, there are less goods and services subject to sales tax being purchased. Therefore, the revenue goes down, then the share that's attributable to counties goes down. That's a very good point. I don't have that slide here, but Forward Analytics, again, Dale Knapp and Kevin Dosboy at the association have prepared a graph going back, I think, 20 years, showing the growth in sales tax revenues. If you're interested in seeing historically what has sales tax revenue done, take a look at that graph. And again, I don't want to misquote. The graph has the figures, but I believe it's about a 3% and maybe north of 3% annualized rate of return average over the past 20 to 25 years. And so, yeah, there are years where that sales tax revenue is going to go down. Off the top of my head, I know 2009, 2010, I think we saw a dip in revenues based upon what was happening in the economy. But we saw it climb significantly in the years following that. And so, yes, the counties are going to share in both the good and the bad. Question about emergency management. The county can't share emergency management directors because of state rules requiring that an emergency management director be appointed in each county. Is WCA working to address this limitation or change in rules? Ken, I don't know the answer as to what the association is working on right now as it relates to some of those rules, but I think, as I mentioned at the beginning, as we get through some of the questions and open issues in Act 12, that there will be opportunity to have discussions with DOR, DOA, and perhaps legislators about addressing some of those problems that we might see with that. All right. There are additional exclusions on the calculation for determining whether a county is eligible for an expenditure restraint grant. That's an existing program in 7905. And so again, there are modifications contained within Act 12 as it relates to the entire process of shared revenue. To Matt's point, I would encourage you to read through those provisions to find out what is or is not applicable in your particular county. So as I mentioned, there are some strings attached to this entire process as it relates to making available to counties enhanced funding opportunity. And one of those strings is a maintenance of effort requirement. This applies to all counties and all municipalities that receive shared revenue. And Matt was kind enough to put the exact statutory language from Act 12 right here on this slide as it relates to maintenance of effort for EMS. And it also applies to fire protective services, but I know that's not a county issue typically. Mostly we're dealing with EMS at the county level. And even with EMS, the way that we deal with EMS from county to county varies significantly. There are some counties that run their own EMS department. There are a lot of other counties that distribute money out to municipalities for purposes of supporting EMS. There are still other counties that have an EMS unit that works in tandem with their municipal partners in providing EMS countywide. And so the entire process and the entire program of providing EMS varies county by county by county, but the legislation doesn't distinguish between those various service delivery models. The legislation simply requires maintenance of effort. And so a political subdivision, which includes county, city, village, town, has to certify to DOR, all right, annually, that the level of EMS, level of emergency medical service, is at least equivalent to that provided in the previous year, all right? And so I know that the question we were going to get is, what does equivalent mean? How do we do that? What is the certification? All right, and so if we look at what is required in the certification, you have to hit 2 of the 4 bullets that are on this slide. First, county's expenditures, not including capital or expenditures of grant monies, is the same as or greater than the year prior for EMS. I think that's a relatively simple calculation if we look at our budgets and we look at our financial statements. If the money that we spent in the current year is the same as or greater than last year, we'll be able to certify that first bullet point. Bullet points 2, 3, and 4 is where we get a bit into the weeds operationally as it relates to the maintenance of effort requirement, which might be a little bit more difficult for certain counties. All right. Look at the second bullet point. The number of full-time EMS personnel employed by or assigned by the county, not including firefighters or emergency medical service personnel whose positions are funded by grants, has to be the same as or greater than it was the year prior. Well, as I mentioned, there are counties that maintain their own EMS system. So I think that bullet point will be relatively simple to figure out for those counties. But there are many counties who support EMS within their county in a way other than the direct provision of services. So how is it that a county would be able to certify as to personnel? Matt and I had this debate earlier this morning. Well, if the answer is 0, can we just certify 0? And that's going to be okay to the Department of Revenue? I don't know the answer to that. And that's something, again, highlighting the need to have continued discussions with the Department of Revenue as it relates to expectations on this second certification bullet point. Third, level of training and maintenance of licensure for EMS. Providing EMS services within the political subdivision is the same as or greater than it was the year prior. Again, same issue. If we don't directly employ EMS personnel, how do we make this certification? And then finally, we have a measurement of response times for EMS services throughout the county, adjusted for location of calls for service. Well, that's all fine and good. And I imagine a county could get its hands on the data necessary to certify the fourth bullet point, but that's out of the county's control in many, many circumstances. So how is it that a county is responsible for certifying certain EMS operational items when those operational items are not within the county's control? And so I think all of this, and again, this is a discussion, not necessarily telling you exactly how this is going to be interpreted, because we have to wait for the administrative regulations. But I think this is all telling us that we need to start discussions with our city, village, and town colleagues about how it is that we, meaning all of the municipal entities within a county, are going to comply with the maintenance of effort requirements. Because at least in my estimation, I think there ought to be consistency in the reporting and certification that occurs as it relates to maintenance of effort. If we have consistency and we can lay out the entire story, if you will, for EMS throughout the entire county, I think that that's going to satisfy a lot of the requirements that are contained within Act 12. If there's inconsistency and people certifying different things, I think that's just going to lead to problems. Why don't I pause there, Matt, because I know that you've examined these certification requirements quite a bit, and I know you and I have discussed this. Anything you want to add there?
No, I mean, I would encourage folks to look at some of the exceptions which address situations, for example, where, you know, political subdivisions consolidate services with another political subdivision. I know there's an exception from certification, I think, for the first year after consolidation. So I would encourage folks to take a look at those and just know when those might be applicable.
Oh, look at that. Dale chimed in right on cue, and he said sales tax has gone down only twice in its history. That was in 2009, 2010. Average annual growth since 2000 is 3.4%. So thank you for that information, Dale. And again, if you want to dig into the numbers, call the Counties Association and Dale Knapp, because he and his team are much brighter than Matt or I at answering math questions. Had another point here in the chat. If we report in July of 24, we're certifying 24 levels year to date or same or greater than 23. I don't know the answer to that in terms of exactly how the Department of Revenue is going to measure maintenance of effort in terms of what time frame they're going to look at. That again is something that we need to work with the Department of Revenue on as they go through the process of establishing the forms and requirements associated with this reporting and certification. I say this understanding full well that the state is on a biennial budget, and it also operates on a fiscal year, July 1 to June 30. We don't operate on that same fiscal year. We're January 1 through December 31. And so somehow we have to marry up those two different fiscal years to provide the certifications and reporting. Question: what if the county doesn't provide any funding for fire and EMS? The cities, villages, and townships provide these services. Matt, I think that that is the best situation a county can have, because you're not required to certify anything at that point. Do you agree?
I think that's right, but I want to confirm that and get back. I think that's right.
The way that Act 12 reads, that's the way that I read it as well. Second question from Jenny in Portage County: what does or assigned to the political subdivision in the second bullet point mean? I think that that references, for example, in certain townships and villages and cities, you have volunteer fire departments that are providing the services within that city, village, or township. And so that would be an example of a firefighter that is assigned to a political subdivision, even though that person is not employed by the political subdivision. We have a very long point in chat as it relates to the LFB memo. or excuse me, yeah, or it might be alleged Counsel Act memo as it relates to the maintenance of effort. And so there is supplemental material that's available explaining what it is within Act 12. Take a look at that supplemental material as well, because that gives insight as to it's considered legislative history in that it's a real-time memo from a state agency, in this case, Legislative Council or Fiscal Bureau, that explains the provisions within an act. Act 12 has some of that material. Take a look at that material because it provides good explanation.
Andy, so following up on that question about a county that doesn't provide any EMS or fire. The way I read the act, I would think that county would need to make a certification. It would just be an easy certification to make because, you know, if you haven't been providing it and you're still not providing it, you're maintaining the same level of effort that you've done before. And the reason I say that is because there is a specific provision in the act that addresses cities, villages, or towns that don't provide law enforcement services, but receive those from the county. And they are essentially told that they can make a statement to that effect rather than doing a certification. But there's nothing similar for a county that doesn't provide EMS or fire protection. There's no similar provision providing an exception to the certification requirement.
No, and I think I mean, that highlights the need for further discussions
Yeah.
with DOR and frankly, the legislature to make sure that we are not put in a position as counties of certifying something that can't exist and doesn't exist. And that's my big concern. I know it's yours too, Matt, is that from a legal standpoint, a certification is essentially a sworn statement saying, here's what it is. And we want to avoid certifying something that is either outside our control or certifying something that we have no ability to certify. So we're going to have to continue to discuss that.
Yeah, I think looking at a provision similar to the one that applies with respect to law enforcement for the locals that don't provide their own law enforcement might make sense.
Here's a good point from Samantha does this mean a levy needs to be maintained for law enforcement? The act talks about expenditure, not levy. Excluded from the term expenditure are capital expenditures or grant money expenditures, but it doesn't speak to levy contribution. This is important because if you remember when we talked about the new shared revenue process and the formula, I said that you have the ability to shift money between departments, okay? It's not a levy contribution that is measured, it's an expenditure. So that's very important. So we have to certify expenditures have been maintained. We have a question about inability to fill a position. That's an example of a situation where we're going to have to work through some of these kinks. I know that people are having a really hard time filling vacant EMS positions, filling vacant jailer positions, filling vacant CNA positions in a nursing home. All of those things exist. So how can we, again, certify a maintenance of effort when we've been recruiting for certain positions for 6 months, a year, 2 years, and we just can't fill the positions? We have to work with DNR on that. Not DOR, not DNR. All right, a couple of finer points as it relates to the certifications. Okay, if a county's consolidated EMS or entered into contract with a private entity for EMS, we can provide a certified statement to that effect in lieu of the required certification. If we have a newly established or joined a newly established EMS agency, we can provide a certified statement to that effect in lieu of the required certification. The final bullet point on this slide is not important to counties, but it's important to cities, villages, and towns. And that is if the city or village of town is allowed by law, and this applies to cities and villages under a certain population and to towns, where they can say, look, we're not going to have our own police department. The sheriff's going to cover us. It's fine. If that happens on a non-contractual basis, because a town, for example, can contract with the sheriff's office to provide law enforcement services specific to the town, but say we don't have that contract, then the city, village, or town can indicate to DOR that on a non-contractual basis, the sheriff covers this. Why do I bring this up? Because I know it's been a point of concern in certain counties where towns have indicated or villages have indicated that is a sheriff's responsibility to provide law enforcement services within the jurisdictional boundaries of a particular town or village. And I want to reiterate that that's not the case, that a sheriff has constitutional authority to provide law enforcement services as the sheriff best sees fit. And so it will be, in my estimation, interesting to see what is going to be certified in those cities, villages, or towns as it relates to law enforcement services. Anything you want to add on that, Matt?
No, I don't think so. I mean, yeah, there's a lot we could get into in the disputes between other local municipalities and counties with respect to law enforcement, but.
Okay, so does the maintenance of effort, is it a set in time measurement, meaning we calculate it in 2023 and forever 2023 is our standard for maintenance of effort? No, it's based upon year over year over year. And so if you look at the certification provisions contained within Act 12, it's always a comparison to the year prior. Question, can we go back and confirm that counties are exempt from the law enforcement MOE requirement? They are not. Counties have a requirement to maintain efforts, law enforcement, right, Matt?
Yes.
All right. So moving on from some of the particulars as it relates to maintenance of efforts, transfer of services levy limit adjustments. If everybody remembers, under law existing prior to Act 12, there was a built-in, I think, disincentive as it relates to transfer of services between municipal entities, whereas the receiving entity, the entity that took on the service responsibility, got the increased levy by the amount of those services, and the entity that relinquished itself of that responsibility had to decrease its levy. That doesn't apply anymore unless the two entities file a statement to that effect with the Department of Revenue. All right, and so there is a requirement that a statement be filed that's contained in these new statutes as it relates to transfer of services. But I asked this question at the bottom, and we're still working through the kinks, and I get that. We're still trying to understand exactly how the new shared revenue process works for counties, and I get that. But when we have an innovation grant fund available to us that is going to provide supplemental funding and resources in order to collaborate, in order to work together with the private sector, why is it that we would ever file a statement about increasing or decreasing our levy? Now, it might become apparent to me down the road that we still want to do something like this, but I think as we work through some of the details on the innovation grant program, that we're going to see a greater benefit through that grant program than we see currently with the levy limit adjustment for transfer of services language. We're going to talk briefly about quarries. And before I do that, let me just check and see if we have questions here. Okay, quick question. Can we clarify expenditures? Expenditures total minus offsetting revenues or just expenditures? Let me just start by saying that, remember, expenditures is defined to exclude grant monies. And so I think we have to net out what it means for expenditures, but it's a comparison of expenditures, not offsetting revenues and things of that nature. But we also cannot include within expenditures certain categories like grant money. Okay, Ken says this is huge for us in Door County. We're piloting transfers at a local hospital. And I agree. I think this is going to be a big issue as it relates to certain counties and certain programs that they operate in conjunction with state or federal government or other entities, where does the money qualify as an expenditure? So I think we have to work through some of those issues as it relates to the certification process with the Department of Revenue. Next question, would it be the certification for law enforcement if you had a new village created and you now started a contract with that new village for law enforcement? I was talking about the village certification in that circumstance. So let's imagine that village contracts with sheriff's office for law enforcement. That contract is a transfer of money from village over to county, and in exchange, county provides law enforcement services in that village according to the terms of that contract. The village is going to certify to the Department of Revenue that it satisfies its law enforcement maintenance of effort requirement through a contract with the county. All right. Let's talk briefly about quarries here. I think we've gone through, Point said counties were exempt from the law enforcement maintenance of effort, and I apologize if the slide is incorrect there on counties being exempt from a law enforcement maintenance of efforts. I apologize. But Matt, maybe can you clarify as it relates to law enforcement maintenance of effort that counties are required to comply?
So I've seen a lot of confusion on this point too, in some of the materials that have been put together on Act 12. But if you read the statute with respect to the law enforcement maintenance or effort, it says a city, village, or town with a population of greater than 20,000 shall certify that the city, village, or town has maintained a level of law enforcement that is equivalent. So it's cities, villages, towns.
So it does not include counties. So I misspoke.
So when we're talking about maintenance of effort for law enforcement, as I understand the statute, counties do not have to do a certification with respect to law enforcement.
Okay, I apologize then, because that was a point that I raised in answer to Sarah's previous question. And I said counties are required on maintenance of effort for law enforcement. The answer is no, according to Act 12, they are not. EMS, however, counties are required maintenance of effort on EMS. Is that right?
Correct. So if you read the statute on fire protection and EMS, it refers to political subdivisions. And
Perfect.
counties are included in the
Okay.
definition of political subdivision.
Okay, good. Perfect. So now we have clarity. All right. So moving on, dealing with regulation of non-metallic quarries. This is an issue that frankly has been discussed over the course of the past, gosh, I want to say 3 budget cycles and 3 legislative cycles. And it is a desire on the part of quarry operators to shed themselves of what they view to be unreasonable regulations imposed on those quarry operators, primarily by towns. Okay, so the focus of this statutory language in Act 12 is on limiting town government's authority to regulate quarries. For the most part, the argument from the quarry operators was not with county government, and it was not with county government's ability to regulate quarries through the conditional use permitting process. What quarries were concerned about with is towns' abilities to regulate through non-zoning ordinance the operation of a quarry. From a quarry operator standpoint, they were concerned, and I think that Department of Transportation was concerned as well, with inhibiting the creation and distribution of aggregate materials to support road construction projects. And so we see in Act 12 language that limits authority to regulate quarries. Now, some of the provisions of Act 12 as it relates to limitations on regulation of quarries applies to counties. But again, the primary focus of this language is to limit town authority to regulate through non-zoning ordinances the regulation of these quarries. Okay. So again, you'll see provisions in Act 12. The points that I want to make is that, again, when you see the terms like non-metallic licensing permit, they're really looking at those non-zoning permits that towns require as part of their regulatory mechanism, not dealing with the county CUP permit process, which remains intact in Act 12. But there are limitations as it relates to counties' regulation of these non-metallic quarries. Blasting regulations are one of the examples, all right? Hours of operation are another example. And so what we see here is if the materials produced at the quarry are going to be used in a public works project that requires construction work to be performed during the night or it's an emergency repair, we cannot limit hours of operation. As I mentioned before, blasting regulations are taken out of a county and a town's hands and placed squarely as a responsibility of DSPS. DSPS is going to formulate an administrative rule mechanism that regulates blasting. Act 12 says that DSPS rule is going to be the standard as it relates to blasting regulations, and counties and municipalities, primarily towns, have no ability to deviate from what DSPS has said. Financial reporting. This is an important process as well. There is going to be a process whereby DOR gathers and calculates information to produce comparative reports as it relates to local government expenditures. A provision in Act 12 having nothing to do with finances, but made its way into Act 12 is a ban on preferences in hiring and contracting. And again, there's been a lot of discussion, I think confusion about what this ban does. So let's take a look at the actual statutory language here. Unless required to secure federal aid, no political subdivision, including a county, may discriminate against or grant preferential treatment on the basis of race, color, ancestry, national origin, or sexual orientation. That's the provision that says that we can't grant preference and we can't discriminate on the basis of. But here's the limitation: in either making an employment decision or in contracting for a project of public works. So, as it relates to any preferences or bans on discrimination that may find their way in, not a ban on discrimination because current law doesn't allow it anyways, but as it relates to preferences, for example, in contracting. If a county has a program to provide opportunity to DBEs or MBEs, those disadvantaged enterprises, as long as it is not granting preference on a project of public work, that is okay. And I say that with a little bit of consternation, I guess, because we don't have the ability as counties to discriminate and give advantage or preferential treatment to a disadvantaged enterprise on a project of public works under current law. If you look at 59.52 sub 29 of the statutes and 66.0901, what is our requirement on a project of public works? We have to award the bid to the lowest qualified bidder. We don't have the ability to grant preference. And so, again, I think that this statute is a codification of current law. But again, if you have concerns or questions about how this relates to your particular county, please reach out to us and let us know. A ban on advisory referenda. And I think that many of you are probably aware and have seen the proliferation of things appearing on the ballot for advisory purposes utilized by both political parties to draw out voters. We saw legalization of marijuana. We saw bail reform. We saw items like that appear on the local ballot in an effort, I think, by the political parties to encourage voters to the ballot box. And so the legislature took a look at that, didn't agree with it, wanted to end the practice. And so it essentially modified 59.52.25 by striking out the term for advisory purposes. All right. So now, under the law after Act 12, we as counties can still authorize a countywide referendum, but only for the purpose of ratifying or validating a resolution that has been adopted or an ordinance enacted by the board that is contingent upon approval through the referendum process. Now, there's an exception to that for revenue sharing agreements under 660305 sub 6, which currently recognize the ability to have an advisory referendum on those agreements. All right, so that exception is in there. But again, it eliminates that entire provision allowing for referenda for advisory purposes only. We had the repeal of the personal property tax that occurred within Act 12. This is a circumstance where Act 12 has to be viewed in conjunction with Act 19, because Act 12 eliminates the personal property tax. Act 19 contains an appropriation to make counties whole for the elimination of the revenue stream coming from personal property tax. Act 12 also contains language specifically dealing with the question of what property is going to be taxable, so to speak, if it is enrolled in the managed forest land program. 77.84 sub 1 was modified by Act 12 to make clear that buildings, improvements, and fixtures on managed forest land is going to be subject to real property tax under Chapter 70. So in other words, whereas some of those components or personal property that was contained on managed forest land was previously taxed as personal property, it's now going to be taxed as real property under Chapter 70. This applies to assessments that occur starting on January 1, 2024. Another provision contained within Act 12 is a restriction on the power of local health officers. I think there was a lot, well, I know there was a lot of controversy about local health officer authority emanating from the COVID-19 pandemic. Question was whether local health officers had the ability to issue orders that were going to be enforceable, shutting down certain businesses, keeping other businesses open, imposing certain conditions upon the general public, and so on. And so as it relates to a local health officer's authority to issue an order that health officer deems reasonable and necessary to combat the spread of a communicable disease, Act 12 contains an additional provision which says that if that order mandates that any business be closed, that order only exists for 30 days unless the county board, or in the case of a municipal health officer, the city or village board or city council, unless that board extends that order, and the extension can only happen for another 30 days. And so the maximum duration of any order of that type is going to be 60 days, 30 days by the health officer, 30-day extension by the county board. Any mandate to close a business cannot distinguish between an essential and non-essential business. It's either all or nothing as it relates to the closure of those businesses. Anything, I know we've got a couple of comments here I want to read quick. Anything you wanted to add on the last couple of slides, Matt?
No, I mean, I will say when I read the restriction on the power of the local health officers, and I actually looked at the statute, you know, I think it is the case that you're only allowed one 30-day extension. However, that's not crystal clear, if that makes sense. And so, you know, I suppose somebody at some point could try to come up with a creative argument that, you know, you have to come back every 30 days for extensions, but I think probably, you know, it wasn't crystal clear to me. Does that make sense?
Yeah, that makes sense. And I mean, honestly, I hope to God in my lifetime we never deal with another COVID-19 type pandemic. But I've been told by several health experts it's not a matter of if, it's a matter of when. So I think that when we see legislation like this that's reactive to what had occurred during the COVID-19 pandemic, who knows what's going to happen with the next set of circumstances that is thrust upon us. But I think that's right, Matt. There are several questions. I mean, frankly, there are several questions that remain unresolved as it relates to local health officer, and for that matter, DHS and state health officer authority as it relates to combating the spread of a communicable disease. We'll have to deal with that. A couple of points. Christie, Portage County points out that DOR should define what grant funding is as it relates to the maintenance of effort obligation. Couldn't agree more, because, you know, grants, well, what is a grant? Is that funding from other private entities, a donation of that sort? Is it a grant process from another governmental entity? What is a grant? I think that's a great example of something that we ought to seek clarification from the Department of Revenue. Second, Terry and Kenosha County on the elimination of the personal property tax and how we are going to ensure that the appropriate buildings, so to speak, are taxed if they're enrolled in the MFL program. Terry, all I can say to you is that we're going to have to work closely with our assessors to make sure that we have consistency in terms of what the assessors view as assessable property. All right. Matt, do you want to talk a little bit about the shift in regulatory authority over ambulance staffing and licensing? Because this is a circumstance where we have current administrative regulations that require one thing, and the legislature stepped in and said, oh, by the way, we're going to allow this. And this may, again, this isn't going to apply to every county, but I think it does. It's an attempt on the part of the legislature to try to provide additional flexibility for counties and municipalities and EMS to get people providing EMS.
Sure. Yeah, I can run through your first bullet. You know, there's now a prohibition on an ambulance service provider or an EMS program from prohibiting their employees or volunteers from being employed by or volunteering with another ambulance service provider or EMS program. You know, I guess so to the extent anybody out there is running an EMS program and has those types of prohibitions, that would be something you would want to look at. There's a change in staffing requirements for non-emergent interfacility transports, essentially loosening the staffing requirements associated with those types of transports. I think previously you needed an EMT and I think a training permit holder to be there. Now I think you just need one EMT and somebody who's CPR certified. To do that, I just encourage you to look at the details of the statute. There's a prohibition on DHS requiring certain equipment to be stocked in rural ambulance service providers as a condition for upgrading their service level. I think a big one is this question of certification with the National Registry and taking the National Registry test as a condition to be employed as an emergency medical responder, which, as I understand it, is sort of the lowest level of certification. I think previously DHS was requiring that registration with the National Registry and taking the assessment in order for people to be emergency medical responders. Now state law essentially prohibits DHS from doing that, but an EMS program or an ambulance service provider can itself make the decision whether an emergency medical responder needs to be registered or take the test. So, I mean, I think effectively it provides for more local control over those testing and testing and registration requirements. Similarly, with respect to the use of prior education, training, and experience in connection with military service, to have somebody be certified as an emergency medical responder. I think previously DHS would make the determination as to whether or not prior service would allow for certification as an emergency medical responder. Now that decision is more in the hands of the ambulance service provider or EMS program itself. So they would make that determination with respect to their volunteers or their employees.
There were also some changes to the stewardship program. As you might remember, this is a program that the state administers in order to acquire land for purposes of creating parkland or open land. And so the Act 12 requirement is now, whereas before there was not a requirement, but counties, for example, could adopt a resolution that would be advisory to the Department of Administration in administering this program, either in support of or opposed to the state acquiring that land under the stewardship program and creating the park. Now, as it relates to south of US Highway 8, that is still a non-binding advisory type resolution, but north of Highway 8, if land is going to be acquired under the program and used for park purposes, DNR, excuse me, I think I said Department of Administration, I meant Department of Natural Resources. DNR cannot approve the use of these stewardship funds for the acquisition unless every local government in which the land is located adopts a resolution approving the acquisition. So essentially, the county would have veto authority, if you will, over DNR's acquisition of land using these stewardship funds. Again, north of Highway 8. Other Act 12 provisions of note that we just wanted to highlight for you very quickly. If we look at 70.119, there was a process whereby the county would negotiate or municipalities would negotiate with hospitals and clinics authority because they're exempt from taxation as it relates to special charges. Counties are excluded from the list of municipalities that DOA has to negotiate with for the provision of those municipal services. Not quite sure, at least from my understanding, exactly what the impact is and what counties currently do or may currently negotiate with DOA, but counties are excluded from this list. Then we had, and this is something that was a bit of a head scratcher to me, is that we had modification of 59.605 of the statutes, which is the county levy rate limit statute. Some of you may be old enough to remember that in 2011, that entire statute was sunsetted. It's contained right there within the statute that as of 2011, it's sunset. We're told that this was a drafting error on the part of LRB in including the modifications to 59.605. And so If you read that and think, are we reviving the county levy rate limit? The answer we've been told is no. There was no change to the sunsetting language that's contained within that statute. So it's a bit of a head scratcher as to why that was included, other than it being just a flat out mistake. So with that, we're at the point where we're on to questions. We've got one here. Can we confirm that we should not budget for personal property tax revenue for 24 annual budget and going forward? Again, I would defer to Kyle Christensen, Mark O'Connell, and the WCA team on that, but it is my understanding that with the repeal of the personal property tax, the money that would come in from personal property tax is gone, but there is a hold harmless contained within the biennial budget so that counties receive an appropriation that will make up the money that is lost through personal property tax revenue. So while you should not budget the receipt of revenue from personal property tax for 2024, you are going to budget based upon the revenues that are anticipated from the state as that makeup, if you will, for the elimination of personal property tax. Matt, anything I missed that you think is really important to talk about with Act 12? I know we covered a lot.
No, I don't think so.
Okay, so we'll wait the next couple of minutes to see if additional questions or comments come in. I would really encourage you as you go through Act 12 in conjunction with Act 19. And if you have questions about implementation, how Act 12 is going to work, please reach out to the Counties Association so we can get those questions answered for you. And again, we're trying to work through some of those open issues and questions ourselves. And so we're going to continue discussions with the Department of Revenue, Department of Administration, Governor's Office, the legislature to have some clarity. As we get additional clarity, we'll obviously pass that along to all of you. But again, if you have questions or concerns, please reach out to the Counties Association. I don't know if Mark, we've got a couple of minutes, if there's anything you wanted to add in terms of Act 12 and some thoughts that you have about what we've discussed.
Yeah, sure. While this legislation was a lot of minds and brain power was put into it, it is a different approach, and there are several elements of the legislation that may need to be tweaked or may need interpretation, or in some cases possibly may need to be settled in the courts. So as not all the answers are crystal clear right up front, as you heard today, but to the extent that we have challenges with any of the legislation or interpretations, give us a call and we will see what we can do to clarify that and chart a course to get us to where we need to be. And if not, we may need follow-up legislation in the future to help clarify. Hopefully that's not the case, but we'll see as we move along. Some of this is brand new. Innovation Fund is brand new. And so how it works, well, nothing's worked so far. So we don't have any good examples yet. Hopefully we will. And if you have ideas and thoughts on how you might take advantage of that, we would love to assist you in trying to get those dollars into you. With that, I suspect, do we have more questions come up here, Andy?
I haven't seen any additional questions, Mark. I think we've gone through all the questions. I'll just confirm that I know that the presentation is being recorded and will be made available as soon as it's available to the association on the website, as well as the slide deck that we have here. So if you wouldn't mind being patient a little bit, I know we'll get that information up for everybody.
Michelle will get that up on the website probably by the end of the day. So we'll be on the job. With that, thank you all for joining, taking an hour out of your day. And if we have further questions, we will certainly be free to get together again. Thank you all, and thank you, Attolles.
Thank you.